Democratic legislators introduced a bill Thursday that would add 4 seats to the U.S. Supreme Court.
In the history of
House Speaker Nancy Pelosi says while she's not ruling out the expansion for now, she will not bring the bill to a vote. But House Minority Leader Kevin McCarthy says the Democrats' proposal should scare every single American. The term court packing is back in the news. What is it and why does it matter? Inside Congress, lawmakers fiercely divided. But where do Americans stand on the issue? 3 national surveys give insight. And while Facebook and Twitter are both tightening the web of censorship on their platforms, MyPillow CEO Mike Lindell's launching his new social media platform. He says its mission is to provide a place for free speech. Tune in a deep dive as we explore these topics and more. Hello and welcome. This is Deep Dive and I'm Tiffany Meier. Lots of talk about court packing lately. What is it and why does it matter? But first, let's talk about free speech. MyPillow CEO Mike Lindell's new social media platform will launch on April 19th. He says its mission is to provide a place for free speech. The new platform is called Frank, and its mission is to provide a place for free speech. Frank is described as a combination of Twitter and YouTube. In a video statement, Lindell said he's taken steps to make sure the site is secure and uses its own servers. He says it won't be subject to big tech censorship. But threatening violence and foul language won't be allowed. Lindell tells the Epoch Times that Frank is projected to draw tens of millions of users in the first week of operation. This comes as Twitter has permanently suspended Project Veritas' James O'Keefe. That's after the latest batch of undercover videos exposing CNN. O'Keefe posted a screenshot on Telegram where Twitter said in an email he was permanently suspended specifically for fake accounts used to manipulate Twitter conversations. O'Keefe says he'll be suing Twitter for defamation. This comes as another social media giant, Facebook, has blocked all sharings of the New York Post's coverage of Black Lives Matter's co-founder purchasing multi-million-dollar properties in Los Angeles. New York Post is the 4th largest newspaper in the U.S. Soon after, Facebook also censored the Daily Mail's coverage of the topic. Daily Mail is the 3rd largest newspaper in the U.K. Now let's turn to the latest debate, court packing. Democrats in both chambers of Congress Thursday unveiled legislation that would expand the U.S. Supreme Court. Called Judiciary Act of 2021, the bill seeks to increase the number of seats on the High Court from the current 9 to 13. House Speaker Nancy Pelosi says she's not committing to bringing the bill to a vote. She said expanding the Supreme Court could happen, but should be studied first, adding while she doesn't know if the idea is good or bad, it should be considered. She goes on to say, and I think the president's taking the right approach to have a commission to study such a thing. It's a big step. It's not out of the question. It has been done before in the history of our country a long time ago. Republicans note that Congress rejected the last presidential effort at expansion by Democrat Franklin Roosevelt. In an interview with Fox Business Thursday, House Minority Leader Kevin McCarthy argued that the Democrats' proposal to add 4 seats to the court should scare every single American, regardless of where they stand politically. At his weekly press conference, McCarthy said he never believed Democrats would go this far. President Biden signed an executive order last week, establishing a 36-member commission to study possible reforms to the Supreme Court, including expansion. And to counter it, Republican Congressman Andy Biggs introduced a constitutional amendment to keep the Supreme Court at 9 justices. Biggs said in a statement, the Supreme Court must faithfully interpret the Constitution. We cannot allow it to fall victim to partisan attempts to pack it with far-left radicals. Adding this desperate power grab by Democrats will only further divide our nation. I will not stand for a Supreme coup of our highest court. But the move is unlikely to pass, given the requirements of a constitutional amendment and the Democrat majority in Congress. And where do Americans stand on the issue? National surveys conducted last year give some insight. Several surveys went out amidst the presidential election last fall, particularly after Justice Ruth Bader Ginsburg died. Suddenly, all eyes were on the Supreme Court and what might happen there. Also last fall is when conservative-leaning federal judge Amy Coney Barrett was confirmed to fill the seat. 3 different national surveys all found the majority of Americans oppose the idea of expanding the Supreme Court. According to a New York Times Siena College national poll during the peak of the presidential election, a majority responded saying Democrats should not expand the Supreme Court over the current 9 justices. 58% voted against, 31% for, and 11% undecided. Among those numbers, quite a contrast between party lines. 57% of Democrats said the Supreme Court should be extended beyond 9 justices, 28% against. That's in contrast to a mere 6% of Republicans who voted for it, with a whopping 89% against. Independents voted more along Republican lines as well, with 25% for and 65% against. A different poll by ABC News and The Washington Post also showed a majority against court packing. 54% voted against, 32% voted for, and 12% unsure. And a Fox News poll also found a majority were against expanding the Supreme Court. 41% voted against, and 39% favored the move. And what about Biden? Reporters pressed White House Press Secretary Jen Psaki, who responded saying Biden has his own view on the matter, but wouldn't expand on what that view is. Biden has repeatedly faced questions on court packing during his campaign, many citing his own comments on the matter from 2005, when he called it a corrupt power grab. Then Senator of Delaware Biden went after FDR, saying, "Let me describe in some detail the summer of '37. FDR had just come off a landslide victory against Alf Landon. He had a Congress made up to solid New Dealers, but the 9 old men of the Supreme Court were thwarting his agenda." Biden accused FDR of being corrupt, going on to say, "In this environment, Roosevelt, and remember this old adage about power corrupts. Absolute power corrupts absolutely. Corrupted by power, in my view, unveiled his court-packing plan." Speaking of FDR, what was that all about? In 1937, FDR introduced legislation asking Congress to increase the number of Supreme Court justices to up to 15. Presented as a general plan to reorganize the judiciary system, similar to what Biden's trying to do now. At the time, the Supreme Court struck down 2 of his New Deal acts, and 2 more were pending. Critics called his attempt a court-packing scheme. This is likely where the term came from. The National Industrial Recovery Act of 1933, one of FDR's New Deal initiatives. In it, Congress passed it, but FDR signed it into law in June 1933. Just 3 months after becoming president. So what is it? It authorizes industrial and trade associations to establish production codes, set prices and wages, and authorizes the president to regulate industry wages and prices. The Supreme Court ruled it unconstitutional in 1935 in Schechter Poultry Corporation versus the United States. The Agricultural Adjustment Act of 1933 came into effect in May of 1933. It sought to control agricultural prices by inducing farmers to produce less. The government would pay them for livestock that would not go to market and for allocating their land for non-agricultural purposes. It raised prices by reducing supply. In 1936, the Supreme Court ruled that the AAA's funding source, a tax on companies processing farm products, was unconstitutional. But the program resumed in 1938 after a legislative fix. And 2 more New Deal acts have been sued and were pending in the Supreme Court. The Social Security Act of 1935, the Supreme Court Schechter Poultry Corporation versus the United States decision in 1935, prodded FDR to initiate the second New Deal. Part of the second New Deal sets up a system of old age insurance, financed partly by a tax automatically collected and levied equally on workers and employers, and placed in a Social Security trust fund. When a worker reaches 65 years old and retires, they can begin to draw a modest payment. It also establishes a state-federal level system of unemployment insurance and disabilities insurance, similarly financed. This is significant because for the first time, the federal government established direct and ongoing relations with individuals. The National Labor Relations Act, aka Wagner Act of 1935. It gives workers the right to join a union and bargain collectively and forbids employers from interfering in unionization. A board would supervise elections and certify unions and investigate employers for unfair practices. Under this circumstance, FDR believed he should prevent the Supreme Court from striking down the Social Security Act and the Wagner Act, and moved to expand the court in 1937. Under the Judicial Procedures Reform Bill of 1937, FDR would be allowed to appoint up to 6 additional justices to the Supreme Court, for every justice older than 70 years old 6 months and who had served 10 years or more. It was immediately and intensely unpopular among both Republicans and Democrats. Many were concerned that it would set a dangerous precedent. Eventually, though, the Supreme Court decided to not strike down the Social Security Act and the Wagner Act. 2 key justices, including Justice Owen Roberts, changed their positions in response to the threat of court packing. This was known as the switch in time that saved 9. FDR's public image suffered greatly, with many now seeing him as brazen, unprincipled, and dangerously power-hungry. Many influential newspapers called him a dictator, partly due to his court-packing scheme, and partly due to his Executive Reorganization Act of 1937. The act would free executive branch officials from congressional oversight. In November of 1938, midterm election, Democrats lost big. Most of the pro-New Deal Democrats. They lost 6 Senate seats, 71 House seats, and a dozen governorships. Democrats still controlled Congress, but no longer enjoyed pro-New Deal majorities. FDR campaigned actively for pro-New Deal Democrats in the primaries, hoping to rid the Democrat Party of his opponents. But what does the Constitution say about court packing? Since 1869, Supreme Court justices have been set at 9. But there were originally 6 when the Constitution first came into effect. Article 3, Section 1 of the U.S. Constitution gives Congress the authority to establish federal courts. Section 2 gives Congress the authority to restrict the jurisdiction of the Supreme Court. It states in all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Article 3, Section 2, Clause 2 of the Constitution does not regulate the number of Supreme Court justices or their term length. Congress has the power. And now for changes in the number of justices. The Judiciary Act of 1789 set the number at 6, a Chief Justice and 5 Associate Justices. In 1807, Congress increased the number of justices to 7. In 1837, that number was bumped up to 9. And in 1863, it rose to 10. In 1866, Congress passed the Judicial Circuits Act, which shrank the number of justices back down to 7 and prevented President Andrew Johnson from appointing anyone new to the court. In 1869, Congress raised the number of justices to 9. Since then, that's been the number. But what do you think? Let me know below. Thanks for tuning in to Deep Dive. I'm Tiffany Meier, and have a wonderful weekend.